Que no se te pasen los eventos conmemorativos por los 10 años de la Reforma Constitucional de Derechos Humanos y Amparo,
que podrás seguir en nuestras redes sociales. Conoce las sentencias paradigmáticas y de vanguardia de la Corte en temas como
derechos de las personas con discapacidad,
acceso a un medio ambiente sano,
libertad de expresión y acceso a la información,
igualdad y no discriminación,
libre desarrollo de la personalidad,
interés superior de la infancia,
derechos de los pueblos y comunidades indígenas, entre otros.
En la Corte se desarrollan y protegen los derechos humanos de todas las personas.
¿Ya formas parte de la comunidad SCJN Digital?
En las redes sociales de la Corte queremos escucharte.
Síguenos en Twitter,
Facebook,
Instagram
y YouTube.
Comenta y comparte nuestras publicaciones.
Entérate de las sentencias más importantes de la Corte que protegen ampliamente los derechos humanos de todas las personas.
Participa en nuestras transmisiones en vivo
Y conoce el patrimonio artístico del edificio sede de la Corte.
Suscríbete
Dale like.
y comparte.
Que no se te pasen los eventos conmemorativos por los 10 años de la Reforma Constitucional de Derechos Humanos y Amparo,
que podrás seguir en nuestras redes sociales. Conoce las sentencias paradigmáticas y de vanguardia de la Corte en temas como
derechos de las personas con discapacidad,
acceso a un medio ambiente sano,
libertad de expresión y acceso a la información,
igualdad y no discriminación,
libre desarrollo de la personalidad,
interés superior de la infancia,
derechos de los pueblos y comunidades indígenas, entre otros.
En la Corte se desarrollan y protegen los derechos humanos de todas las personas.
Conoce las sentencias de la Corte que protegen los derechos humanos de todas las personas.
Para ampliar tu conocimiento sobre el trabajo jurisdiccional, accede a los libros gratuitos,
Infografías,
videosentencias
comunicados oficiales.
y transmisiones en vivo.
Encuéntranos en Facebook como Suprema Corte de Justicia de la Nación.
Sigue nuestra página oficial
Y sé parte de la Corte Digital. No te pierdas todas las transmisiones en vivo de la Suprema Corte.
Suscríbete a nuestro canal y sigue de cerca las sesiones virtuales del Pleno y las salas de la Corte.
Los mejores contenidos de las áreas especializadas de la Corte los encuentras en la Corte Digital.
Suscríbete
Dale like.
y activa la campanita.
Sigue nuestra cuenta de Twitter @SCJN y entérate de la información oficial sobre la actividad jurisdiccional de la Suprema Corte de Justicia de la Nación, comunicados, convocatorias, cursos, conferencias y seminarios. Inscríbete a las actividades en línea y participa.
¿Ya conoces nuestra cuenta de Instagram? Te invitamos a conocerla. Podrás tener acceso a galería fotográfica, martes de descargas gratis, jueves de jurisprudencias, cine reseñas, eventos y convocatorias. Síguenos en @SCJN México, forma parte de la comunidad SCJN Digital y conoce todo lo que la Corte tiene para ti.
Que no se te pasen los eventos conmemorativos por los 10 años de la Reforma Constitucional de Derechos Humanos y Amparo,
que podrás seguir en nuestras redes sociales. Conoce las sentencias paradigmáticas y de vanguardia de la Corte en temas como
derechos de las personas con discapacidad,
acceso a un medio ambiente sano,
libertad de expresión y acceso a la información,
igualdad y no discriminación,
libre desarrollo de la personalidad,
interés superior de la infancia,
derechos de los pueblos y comunidades indígenas, entre otros.
En la Corte se desarrollan y protegen los derechos humanos de todas las personas.
¿Ya formas parte de la comunidad SCJN Digital?
En las redes sociales de la Corte queremos escucharte.
Síguenos en Twitter,
Facebook,
Instagram
y YouTube.
comenta y comparte nuestras publicaciones.
Entérate de las sentencias más importantes de la Corte que protegen ampliamente los derechos humanos de todas las personas.
Participa en nuestras transmisiones en vivo
Y conoce el patrimonio artístico del edificio sede de la Corte.
Suscríbete
Dale like.
y comparte.
Que no se te pasen los eventos conmemorativos por los 10 años de la Reforma Constitucional de Derechos Humanos y Amparo,
que podrás seguir en nuestras redes sociales. Conoce las sentencias paradigmáticas y de vanguardia de la Corte en temas como
derechos de las personas con discapacidad,
acceso a un medio ambiente sano,
libertad de expresión y acceso a la información,
igualdad y no discriminación,
libre desarrollo de la personalidad,
interés superior de la infancia,
derechos de los pueblos y comunidades indígenas, entre otros.
En la Corte se desarrollan y protegen los derechos humanos de todas las personas.
Conoce las sentencias de la Corte que protegen los derechos humanos de todas las personas.
Para ampliar tu conocimiento sobre el trabajo jurisdiccional, accede a los libros gratuitos,
Infografías,
videosentencias
comunicados oficiales.
y transmisiones en vivo.
Encuéntranos en Facebook como Suprema Corte de Justicia de la Nación.
Sigue nuestra página oficial
Y sé parte de la Corte Digital. No te pierdas todas las transmisiones en vivo de la Suprema Corte.
Suscríbete a nuestro canal y sigue de cerca las sesiones virtuales del Pleno y las salas de la Corte.
Los mejores contenidos de las áreas especializadas de la Corte los encuentras en la Corte Digital.
Suscríbete
Dale like.
y activa la campanita.
Sigue nuestra cuenta de Twitter @SCJN y entérate de la información oficial sobre la actividad jurisdiccional de la Suprema Corte de Justicia de la Nación, comunicados, convocatorias, cursos, conferencias y seminarios. Inscríbete a las actividades en línea y participa.
Bienvenidas y bienvenidos a la segunda conferencia del ciclo de reformas de derechos humanos en la voz de juezas y jueces del mundo. Esta conferencia lleva por título la experiencia de Sudáfrica a la luz de la Constitución de 1996, a cargo de la jueza Catherine O'Regan, quien nos acompaña. Muy buenos días, jueza O'Regan. La jueza Catherine O'Regan es jueza en retiro de la Corte Constitucional de Sudáfrica. Estudió la licenciatura en Derecho en la Universidad de Ciudad del Cabo y la maestría en Derecho en la Universidad de Sydney. Obtuvo su doctorado en la Escuela de Economía y Ciencia Política de Londres, la London School of Economics, en 1988. A mediados de los años 80 ejerció como abogada en diversos campos, especialmente en derecho laboral y Derecho Agrario, representando a varios sindicatos emergentes y a sus integrantes, así como a comunidades amenazadas con desalojo bajo las leyes agrarias del apartheid. En 1990 se incorporó como catedrática a la Facultad de Derecho de la Universidad de Ciudad del Cabo. Fue nombrada jueza de la Corte Constitucional de Sudáfrica por Nelson Mandela, mandato que desempeñó entre 1994 y 2009. Posteriormente se desempeñó como jueza ad hoc de la Corte Suprema de Namibia entre 2010 y 2016. Fue presidenta de la Comisión de Investigación de Khayelitsha sobre denuncias de ineficiencia policial y ruptura de confianza entre la policía y la comunidad entre 2012 y 2014, y también fue integrante de juntas y órganos consultivos de organizaciones no gubernamentales que trabajan en las áreas de democracia, Estado de Derecho, derechos humanos e igualdad. Actualmente es la directora del Instituto Bonavero de Derechos Humanos de la Universidad de Oxford. Habiendo hecho esta presentación, vamos a iniciar la conferencia que ya nos ha hecho el favor de pregrabar la jueza O'Regan, y posteriormente procederemos a una sesión de preguntas y respuestas. Muchas gracias.
Everybody, it's a great pleasure to be here today to talk to you, and I am deeply grateful to the Mexican Constitutional Court and to the colleagues who have set up this event. My name is Kate O'Regan, and I am a former judge of the South African Constitutional Court, and I'm going to talk to you today about the role of South Africa's Constitutional Court in its constitutional democracy. My talk is going to start, as it must in relation to South Africa, by talking about our history and the process of constitutional change, because both the history and the process of constitutional change are crucial to the interpretation of the Constitution and to its application. Then I'm going to give you a brief overview of the key provisions of the Constitution. I'm going to talk to you about the Constitutional Court itself, its establishment, its membership, and the work it does. And I'm finally going to talk about a few key areas of the court's jurisprudence, including its rights jurisprudence, both civil and political rights and economic, social, and cultural rights, and its jurisprudence on the structures of state power, and in particular, jurisprudence relating to the president and to parliament. So I'm going to start then talking about the history. Of course, South Africa's history as an apartheid state, and before that as a colony, is well known to many. The colonization started in South Africa in the mid-17th century, very early compared to other African countries. And it began with the establishment of a small European settlement station at the tip of South Africa, where today is the city of Cape Town, in 1652 by the Dutch East India Company. It was only at the beginning of the 19th century that the Cape became a British colony. And in the years following that, in the middle of the 19th century, in the 1840s, what is today the province of KwaZulu-Natal on the east coast of South Africa became another colony, the colony of Natal. And then after a war between the descendants of Dutch settlers and the British Empire at the end of the 19th century, two provinces in the center of South Africa, then called the Transvaal and the Orange River Colony, became the colonies of Britain as well. And South Africa only became one country in 1910 when it became the Union of South Africa. The period of colonization was a period of dispossession of the indigenous African people in South Africa, and that dispossession took place particularly in the 19th century. Following on the Union of South Africa, racially discriminatory laws were legion throughout the country, controls on people's movement, where people were allowed to work, started from very early on in the Union period, many of them having been carried over from the period of colonialism. But in the mid-20th century, in 1948, a government was elected to power as a minority white government. At the time, there were almost no voting rights for people of color, which followed a policy of apartheid, which meant separate development, basically racial discrimination. And that policy of apartheid lasted for just nearly 50 years until 1990. And it was during the period of apartheid, there was an enormous upsurge of resistance to the apartheid government, which resulted in many political leaders being imprisoned, including, of course, former President Nelson Mandela and many, many, many others, and a period of great repression. But in 1990, a process of transition began when the then state president, F.W. de Klerk, announced the unbanning of the liberation movements, particularly the African National Congress and the Pan-Africanist Congress, and the release of many political prisoners, and the beginnings of a process of constitutional discussions. Those constitutional discussions took place somewhat intermittently in the period between 1990 and 1994. It was a period of intense political conflict and change. But in 1994, on the 27th of April, the first democratic elections were held in South Africa, where everybody was entitled to vote. And at that time, a new constitution came into force. But it was not to be the constitution that is currently in force. It was an interim or transitional constitution, and it had been negotiated in that period between 1990 and 1994, between the liberation movements on the one hand and the National Party government on the other. The reason for this period of transition was that there was an immense debate and disagreement between the liberation movements and the National Party government as to whether what they were negotiating in that period between 1990 and 1994, before the first democratic elections, would be a final constitution for the country, or whether it would just be a transitional constitution. The liberation movements did not want it to be the final constitution. They thought that the final constitution should be drafted by newly elected members of a constituent assembly properly representing the people of South Africa, and not in a process of, as it were, bipartisan negotiations, not behind closed doors, but without democratic elections. The National Party government, on the other hand, wanted it to be a final constitution because they expected that once democratic elections were held for the whole of the population, that their political power would have slipped away. For a while, it looked as if this disagreement would lead to an impasse and that no transition would come about. But a solution was found, and that solution was that the constitution negotiated before the democratic elections would indeed be an interim or transitional one. But attached to it, there would be a set of constitutional principles with which the final constitution would have to comply. The question then arose, of course, who would determine whether the final constitution did indeed comply with these constitutional principles? And the answer to that question was to establish a brand new constitutional court, which would be the arbiter of the question whether a new constitution did comply with those constitutional principles. And so a two-phase process of constitution making was set up, with a new constitutional court at its very heart. And so in April 1994, when the first democratic elections were held, members of parliament were appointed both as members of parliament, but also as members of a constitutional assembly, which would, over the next 2 years, negotiate and draft a final constitution. They forwarded that draft constitution to the new Constitutional Court in June 1996. And at that time, the Constitutional Court sat to consider whether that text was indeed consistent with the constitutional principles. The court held that in large part it was, but that in some small but material respects it was not. And the matter was referred back to the Constitutional Assembly, who discussed and effected the necessary changes. And then on the 2nd of February 1997, what became the Constitution of South Africa 1996 came into force. That constitution is a very detailed constitution compared to many other constitutions. It both sets up the structures of government in 3 spheres of government. So the national sphere of government, it provides for 9 provinces, and it also provides for it provides for local or municipal government. So the Constitution recognizes local government as a sphere of government at the constitutional level. And powers and obligations of these different spheres of government are provided for in the Constitution. In addition, the Constitution provides for, obviously, the judiciary, and it provides for a series of independent bodies, which are called Chapter 9 institutions to support constitutional democracy. It also provides for the security forces and the police. It has a chapter on traditional leadership, and it also has a very substantial Bill of Rights. So turning then to the Constitutional Court was, of course, initially established under the interim constitution, because it had to be established there so that it could determine whether the final constitution was consistent with the constitutional principles in the interim constitution. The interim constitution provided for an 11-member court, which had to broadly be reflective of, in appointing judges to the court, there had to be attention to the gender and race demographics of the country. There needed a sense that the judiciary should broadly reflect those. And of the new members of the court, 4 had to have been sitting judges, but in fact, at the end of the day, 6 members of the new court had been sitting judges, and 5 of us had not been sitting judges. When we first met in Johannesburg in October 1994, we had a long agenda to decide a range of questions, which included questions like modes of address, how should the court be addressed, robes, what the court should wear, seniority, would the court adopt a system of seniority, what procedures would the court use, how would it approach the task of judgment writing, and where should the court sit as a permanent home, because it was provided with a temporary home for its first years in office. And in answering these questions, the court really had to think about how to assert the fact that the court was a new court, reflective of a whole new era in South Africa, a democratic era, an era that was inclusive and not discriminatory. But it also had to ensure that people would have confidence in the court. So in deciding things like modes of address, the court decided that it would abandon the historical modes of address that had been adopted from the British Empire, of referring to judges as His Lordship, Mr. Justice so-and-so, or Her Ladyship, Madam Justice so-and-so. Although in 1994 there had been very few female judges, only 2 had ever been appointed in South Africa. And it decided instead to go for the more direct formulation of being either judge or justice, with no honorific or title attached. The court also decided that it would not adopt a system of seniority. And I think in that regard, it is unusual amongst senior appellate courts in not recognizing any system of seniority other than the senior judges. The now Chief Justice and Deputy Chief Justice of the court are the 2 senior judges, and everybody else is of equal status, regardless of their age, regardless of the date upon which they were appointed to the court. The judges are of equal status. And certainly in the Commonwealth experience, that was quite unusual. The court also had to decide on robes, and again sought to illustrate the court's difference to previous courts by adopting a green robe, which was one of the key colors in the new constitutional flag, and which the green robes have been continued to be used to this day. They have made people joke about the court sometimes, because we do look somewhat unusual wearing green, and we have been referred to as the Ninja Turtles and other names of that sort. But they are very distinctive, and people recognize the robes of the court because they're worn in all public appearances of the court. When the court sits to hear cases, the judges are robed. So there were a whole range of things that the court had to decide, and this was very much a self-conscious exercise in a way in the invention of tradition and in recognizing the values that would be needed to be reflected in the invention of that tradition. Perhaps the last thing I should talk about that early meeting of the court was to talk about the court's seal or logo. Again, historically across the Commonwealth, the common seal of a court is the scales of justice, the idea that justice is represented by a weighing scales. But the court decided that that would not be appropriate in the African context, and instead we adopted a logo of the tree, where in traditional forms of justice, justice was often done in communities, outdoors, in public, and under a tree. And so the logo of the court is a tree, and it shows represented underneath it a range of people. And the idea is that, in a sense, that the Constitution and the Constitutional Court are a protector of the people. That has become a very widely known and understood logo, and one sees it used very often in South Africa as a shorthand for the Constitution itself. I've actually got, oh no, I haven't. I thought I would have a logo that I could show you, but in fact, I don't have it here. So it was a very interesting meeting, and one upon which I've reflected very often as being a historic moment. And I'm sure that many courts around the world, when they've been newly established, particularly in a period of the reassertion or establishment of democracy after a period of authoritarianism or apartheid, as happened in South Africa, have had to think about these questions long and hard and think about what the values are that their institution seeks to represent and produce. So turning then to the text of the Constitution, arguably one of the most important parts of the South African Constitution is its preamble. It's the very first words in the Constitution. And what the Constitution says is that the Constitution is being adopted by the people of South Africa so as to heal the divisions of the past and establish a society based on democratic values, social justice, and fundamental human rights. It also says that the Constitution is adopted to lay the foundations for a democratic society in which government is based on the will of the people and every citizen is equally protected by law. It then says that the Constitution seeks to improve the quality of life of all citizens and free the potential of each person, and to build a united and democratic South Africa able to take its rightful place as a sovereign state in the family of nations. This preamble has been cited by the court on many occasions as an important interpretive guide as to how to understand the provisions of the Constitution. The idea that South Africa is turning its back on apartheid and discrimination and colonialism and seeking to build a society in which each person is of equal worth is of founding importance to the interpretation of the South African constitutional text. In addition, the very first section of the Constitution contains a series of founding values, which are also very important interpretive tools. Section 1 states that South Africa is a sovereign democratic state founded on the following values: human dignity, the achievement of equality and the advancement of human rights and freedoms, non-racialism and non-sexism, supremacy of the Constitution and the rule of law, universal adult suffrage, a national common voters' roll, regular elections, and a multi-party system of democratic government to ensure accountability, responsiveness, and openness. And again, these values, human dignity, equality, human rights and freedoms, constitutional supremacy, the rule of law, accountability, responsiveness, and openness in government, are values that are used again and again in the jurisprudence of the court in interpreting and applying the Constitution. The second chapter of the Constitution contains the Bill of Rights, and it is, as many constitutions of the last 30 years, an extensive Bill of Rights. It includes both civil and political rights, as well as social, economic, and cultural rights. It also includes a right to a healthy environment. The Bill of Rights expressly binds the legislature, the executive, the judiciary, and all organs of state, which include all spheres of government, both national, provincial, and local, but all agencies who are performing government functions. In addition, the Bill of Rights binds natural or juristic persons to the extent the right is applicable. This is a provision recognizing that rights have horizontal effect, that citizens, individual natural persons, and corporations bear obligations to respect the Bill of Rights to the extent that they are applicable. Finally, the Bill of Rights is, as many, again, newer constitutions, recognizes a two-stage approach to rights adjudication because it contains a general limitation clause in Section 36, which is somewhat similar to Section 1 of the Canadian Charter. It provides that the rights in the Bill of Rights may be limited by law of general application so long it is reasonable and justifiable to do so in a society, open and democratic society, based on human dignity, equality, and freedom. So this provides for a proportionality approach to assessing whether limitations on rights in the Bill of Rights are indeed consistent with the Constitution. The appointment of judges, of course, is a very important question in any constitutional democracy, and the South African constitutional democracy is no exception. In relation to the Constitutional Court, the Chief Justice and the Deputy Chief Justice are appointed by the President, who does consult with a body called the Judicial Service Commission. The Judicial Service Commission is a body of approximately 23 members who include the Chief Justice, who chairs it, the Minister of Justice, that's the member of the executive or of the cabinet who is responsible for justice, the President of the Supreme Court of Appeal, that's the second highest court in the country, another judge, 4 practicing lawyers, and a professor of law, and then 10 members of Parliament, 4 from the upper house and 6 from the lower house, of whom 3 must be members of the opposition, and 4 presidential nominees. This is a very large body for appointing judges, and it calls for nominations and then shortlists and interviews in public. When judges of the Constitutional Court are being appointed, the Judicial Service Commission presents a list of names to the President that must have 3 more names than the number of vacancies. So if there's 1 vacancy, the Judicial Service Commission will give the President a list of 4 names. If there are 2, a list of 5, and so on. And then the President will choose from that list, again, after consulting with the, in this case, with the Chief Justice, but also with the leader of the opposition and other political parties in the House. So the President makes the final decision, but does consult on it. The Constitutional Court, as I've said, the provisions of the Constitution require that in appointing judges, and that's not only judges of the Constitutional Court, but judges of all the higher courts, that attention should be paid for achieving that the judiciary will broadly reflect the demographic composition in relation to race and gender. And one can see that there's been a significant change in that regard. At the time that I was appointed to the court in October 1994 on the first bench, there were 9 men and 2 women appointed to the court, of whom 7 were white and 4 were black judges. Now in South Africa, the vast majority of South Africans are black, either African or of mixed race or of Indian descent, and only about just under 10% of the population are white. So you can imagine that appointing 7 white judges was not reflective of the broad demographics of the country. But on the other hand, at the time that that first Constitutional Court was appointed, of the 150 judges in the country, all but 3 or 4 were white men. It was already quite a change in the demographics of the bench. That has accelerated in the 25 or 28 years since, and now today as we speak, there are 9 judges on the court, of whom there are 2 vacancies, and 5 are men and 4 are women, so much greater equality between men and women. And at the moment, all 9 judges are black. So there's been a big change in the composition of the court over the last, since 1994. Why why should we worry about the demographics of the bench? This is something, of course, that is often arises. And it seems to me that there are really two reasons. One is that having a diverse bench in a diverse society is that it enhances legitimacy of the court. If it is perceived that certain groups of people are not represented on the bench, then people feel that the bench is somehow excluding them. And therefore it is important to enhance legitimacy. And secondly, and perhaps as importantly, it can enhance impartiality. Coming from a diverse society, one of the things that can happen if we only have people who are all from the same section of that society is that they can confuse their own prejudices for common sense. Diversity enables judges to identify their own blind spot and avoids the reinforcement of prejudice that may happen if judges are selected from a small section of the community who all think alike and have had similar life experiences. One of the reasons we need to be concerned about the goal of diversity, though, is to remind people that the role of judges is not to be representatives. So people are not selected because they're representatives of the particular group from which they come, whether that's their gender, whether it's their ethnic group, whether it's their language group. They are there to be judges for everybody. And their task is to seek to do justice impartially, without fear or favor, to everyone alike. There is no suggestion that judges should in some way seek to favor their own group or represent their own group. And sometimes this is misunderstood, I think, by people when we talk about judicial diversity. So it's something I think it's important to underline. Turning then to the powers of the court, it is a very powerful court, the South African Constitutional Court. Section 2, the very second provision of the Constitution, provides a strong supremacy clause, which states that any conduct or law that is inconsistent with the Constitution is invalid. And under the provisions that regulate the powers of the court, Section 172 of the Constitution states that if a court decides that law or conduct is inconsistent with the Constitution, it must declare it invalid. There is no discretion in that regard. It is compulsory for the court to declare that law or conduct to be inconsistent. So this means that there is some remedial choice in relation to the extent of retrospectivity or suspending an order of invalidity for a period of time, but it's not possible for a court to overlook unconstitutionality. So the Constitutional Court's primary task is to decide constitutional questions. And initially, until 2013, for its first nearly 20 years, the court only decided constitutional questions or matters connected with them. But in 2013, the jurisdiction of the court was expanded to include other questions as well, which the court may consider to raise an arguable point of law of general public importance, which it ought to consider. So although it is called a constitutional court, the South African Constitutional Court is now in fact a general court of appeal and a final court of appeal, much more like the US Supreme Court or the Indian Supreme Court than perhaps its name suggests. Nevertheless, if you actually look at the jurisprudence of the court, the vast majority of its cases remain constitutional cases, although there are times when it does accept non-constitutional cases under the 17th Amendment, which was adopted in 2013. So there are three ways in which cases come before the court: on appeal, which is the most common basis, and by and large, it must come on appeal from the next most senior court, which is called the Supreme Court of Appeal, formerly the Appellate Division, which used to be the senior court in the South African judicial system. Secondly, it can come before the court for confirmation. There's a rather special provision of the South African Constitution which provides that although other high courts have got the power to investigate whether legislation enacted by Parliament or by a province is consistent with the Constitution, they do not have the power to give effect to an order of invalidity. And any provincial legislation or national legislation which is found to be inconsistent with the Constitution by a court other than the Constitutional Court has to be referred to it for confirmation. So every year, a handful of cases come before the Constitutional Court for confirmation. And finally, there are some cases that can come by direct access. Firstly, there are a few areas where the court is the court of first and last instance, the court which is the only court which has the authority to hear a matter. Those areas relate, for example, to the question of whether Parliament or the President has acted inconsistently with a constitutional obligation, the question of the constitutionality of provincial constitutions or constitutional amendments. So a very small selection of particularly sensitive separation of powers questions are reserved only for the Constitutional Court, and those matters, of course, come directly to it. But there is also a possibility to take a case directly to the court with the leave of the court. Applications for direct access may be entertained by the court if the court considers it in the interests of justice to do so. That's rare. In most cases, the court will require litigants to go before other courts and then come to the Constitutional Court on appeal. Although that can make it more expensive for other litigants, it does mean that other courts have considered the matter before the Constitutional Court has done so. There is no jurisdiction under the South African Constitution which would be similar to the Latin American mechanism of tutela, whereby an individual can raise a case and bring it before the court, either before the Constitutional Court or another court directly. There's no immediately similar procedure. So looking to the work of the Constitutional Court, it does not hear a very large number of cases, 30 to 40 cases per year. There's been an increase over the last 10 years or so, but it's still relatively few that it hears in open court with full argument. On the other hand, it receives hundreds of applications every year, and those are considered in chambers. Every single application that's received by the court has got to be heard by a quorum of the court, which is 8 judges. And so there's no small panel process for identifying cases that will be heard. And so a significant amount of the court's time is dealt with considering applications for leave to appeal, the vast majority of which, in the region of 80%, would be unsuccessful. But when it does identify one that it thinks raises important matters that it wishes to hear, it will be enrolled, and then the case will be heard in open court with full argument by counsel on both sides. The court sits in Johannesburg in a beautiful new building, and if you ever visit Johannesburg, I strongly recommend that you go to see the court building. So what have the cases been about? Well, approximately a quarter of all cases before the court have been about challenges to legislation, either at national level or at provincial level. And quite a significant portion of those are upheld, about 3/4 of them. And one of the reasons for that, of course, is that a lot of those challenges to legislation come before the court as applications for confirmation, which means that a lower court, one of the high courts in one of the provinces, has held that the legislation is inconsistent with the Constitution, but it has to come to the Constitutional Court for confirmation. So there's already, as it were, a sifting process in the by cases that are not successful below. Those cases can be appealed to the Constitutional Court if no order has been made below, but they can't come by way of confirmation. And so a significant portion of the cases that come challenging legislation, especially on confirmation, are successful. There doesn't seem to have been much of a decline in the number of declarations of legislative invalidity over the 30 years of the court's, nearly 30 years of the court's operation. And that's, perhaps surprising, knowing that when the court was established in 1994, of course, the statute book was full of legislation that had been enacted by the apartheid government. But we're not seeing a particular drop in the number of unconstitutional legislation found unconstitutional. And I think the other thing to say there is that many of these decisions are uncontroversial. Although in a lot of Anglo-American constitutional theory, there's an enormous anxiety about courts declaring legislation to be inconsistent with the Constitution as giving rise to a counter-majoritarian difficulty. In many of these cases, there is no political contestation at all about it, and there are only a handful of cases where those kind of concerns arise. Many of the cases have been cases to do with criminal procedure, but also equality, a right of access to courts, the freedom of speech, freedom of association, the whole array of civil and political rights, but also, of course, economic and social rights. I've already spoken briefly about the approach in Bill of Rights cases, where the first question is, has there been an infringement or limitation of the right? And then the next question is it a justifiable infringement, which largely involves the exercise of a proportionality test, or the application of a proportionality test. Another thing that might be worth mentioning is the approach to interpretation in the Constitution, because the Bill of Rights contains a specific interpretation clause, which says that when interpreting the Bill of Rights, the court must promote the values that underlie an open and democratic society based on human dignity, equality, and freedom. So again, you see this repetition of the values that we found in the preamble, we found in Section 1, again found in the interpretation section, Section 39. Section 39 also says that when interpreting the Bill of Rights, a court must consider international law. So here is the door that is opened to permit courts in South Africa to consider both international law and norms that are binding upon South Africa and other forms of international law, and determine whether they can assist in interpreting the Bill of Rights. And finally, Section 39 says that the Constitution, that courts may consider foreign law when interpreting the Bill of Rights. So that the debate that has been so vigorous in the United States about whether it's democratically appropriate for the United States Supreme Court and other courts to consider the jurisprudence of other courts when they're interpreting the US Constitution is not a debate that arises in South Africa. Our Constitution makes it clear that it is absolutely legitimate for the courts to do so. In addition to the Bill of Rights jurisprudence, there is a very vigorous jurisprudence on the powers and obligations of the president. So the Constitutional Court has, right from the very first, heard cases challenging conduct of the president. And it's developed a clear set of principles. Firstly, that the president must act lawfully. The president may not exercise any power that has not been lawfully conferred upon him or her. And if the president does so, that conduct or this action of the president will be held to be in breach of the Constitution. Secondly, the president is compelled to act rationally. There must not be arbitrary behavior by the president. And finally, the president must act consistently with the Bill of Rights. And that means that if the president acts in a manner that is discriminatory or in breach of one of the other rights in the Bill of Rights, that too will be unconstitutional conduct. And similarly, and unusually, I think, in the Commonwealth, the court has also got a jurisprudence on Parliament. It has not been unusual for conduct of Parliament to be challenged in the court as unconstitutional. So, for example, the Supreme Court of Appeal, in fact, heard a case on the exclusion of members of Parliament from Parliament and whether it had been fairly done by Parliament, and overturned a decision to exclude a member of Parliament from the chamber. There is also a string of jurisprudence requiring Parliament to act reasonably to facilitate public involvement in legislation, which is a provision provided in the Constitution, and the court has said that Parliament may not ignore its obligation under the Constitution to facilitate public involvement in the legislative process. And finally, the court has heard several cases around issues like the right of private members to introduce legislation into Parliament, the obligation of Parliament to enable press coverage of the events of Parliament, and so on. So we've seen a significant amount of litigation around Parliament. And finally, on economic and social rights, again, as in many Central and Latin American countries, there's a robust jurisprudence on economic and social rights, both the right to health, the right of access to housing, the right to education, the right of access to social security. All of these are rights that have been litigated before the court, and the court has developed a robust jurisprudence in that regard. Most importantly, the court has said that there's an obligation upon government to act reasonably in pursuance of its positive obligation to fulfill economic, social and cultural rights, and the court will scrutinize the conduct of government to determine whether it has been reasonable or not in relation to its positive obligations. So in conclusion then, the South African Constitutional Court has a very powerful role under the South African Constitution to protect and fulfill the Constitution and the rights contained within it. Of course, as in many democracies, South Africa is often the questions of politics and constitutional law that arise are contested. And that's not different to many other constitutional democracies. Nevertheless, in its first 27 years or so, I think we can see that the constitutional text in South Africa has proved a robust document that has provided a value-based guide to this and future generations. It has centrally this idea that government is obliged to seek to promote the values that underlie the constitutional text, the values of human dignity, equality, freedom, as well as the process values of responsiveness, accountability, and openness. And these have been explored in many cases before the courts. I think the courts have sought to preserve a legitimate terrain of politics without abdicating their duty of ensuring that constitutional rights and rules are observed. But obviously, this is a very difficult line to draw and one that is often contested. I think at the end of the day, the example of the South Africa's constitutional democracy shows one that a carefully drafted text can assist in the establishment of a robust democracy, but that it is never a sufficient condition for the establishment of a robust democracy. Most important in ensuring a robust democracy is building a political culture of engagement, accountability, and responsiveness. And that is no easy task. And it's no easy task in established democracies, nor is it an easy task in a new democracy. Thank you very much.
Muchísimas gracias por haber acompañado la conferencia de la jueza O'Regan. Antes de iniciar la sesión de preguntas y respuestas, me gustaría puntualizar algunas cosas de su conferencia que me parecieron particularmente importantes. La primera, la importancia de los procesos constituyentes inclusivos ante situaciones de cambio y de transición de la magnitud de la que vivió Sudáfrica, y cómo el proceso constituyente fue de alguna manera reflejando las tensiones y las dinámicas de este proceso de cambio. En segundo lugar, creo que el otro aspecto que me parece fundamental destacar es el rol que se le asignó en este modelo de cambio a la Corte Constitucional, que constituyó una actora fundamental en el impulso de este proceso de cambio, pero a través de la interpretación del texto constitucional y con los sólidos principios, a partir de la interpretación de los sólidos principios que guiaban el proceso de cambio. Y en este proceso, las diferentes preguntas que se hizo la Corte Constitucional acerca de qué manera podía ser el vehículo de este cambio en ese momento y en este lugar. Las preocupaciones acerca de la representatividad y qué tipo de representatividad debía tener la Corte en relación con las personas, su vínculo con el gobierno, las estrictas facultades respecto del control de constitucionalidad y sobre todo, por último, pero no por ello menos importante, los procedimientos de discusión pública y de audiencia que se dio para resolver todos estos problemas. Me parece que la conferencia muestra cómo, ante momentos claves, las cortes constitucionales pueden ejercer un rol central en la búsqueda del cambio, en el impulso del cambio, pero guiados por principios constitucionales y ser intérpretes dinámicos de estos principios. Dicho esto, quisiera compartirles las preguntas que nos ha hecho el público. La primera pregunta es la siguiente. Tanto Sudáfrica como muchos países en América Latina han sido descritos como democracias constitucionales en transición. En su opinión, ¿cómo pueden seguir las cortes actualmente transformando la realidad y construyendo un puente hacia la democracia? Esta es nuestra primera pregunta. La segunda pregunta.
Thank you very much, Karina. Do you want me to answer that now?
Gracias, Karina. ¿Le gustaría que contestara en este momento esta pregunta?
Sí, por favor.
Me parece que las cortes son más el producto de sus propias historias y sus culturas legales y políticas, así que es bastante complicado proporcionar una respuesta a la pregunta de cuál es el papel que las cortes pueden seguir jugando en momentos de transición para tender esos puentes. Creo que las cortes estarán limitadas y no capacitadas diferentemente dependiendo de dónde estén, pero creo que una de las ventajas de las transiciones en la era moderna es que a menudo son guiadas por textos constitucionales que dentro de ellos tienen no solamente disposiciones específicas, sino también valores explícitos que de hecho articulan los valores en los textos de la Constitución que deberían informar la aplicación y el desarrollo de la Constitución. Esto significa que las cortes no necesitan salirse de los textos de las constituciones, tanto como si lo hacen con constituciones que son más antiguas. Si sus constituciones les dicen que la rendición de cuentas, que la responsabilidad del poder público es un valor constitucional y que la apertura es un valor también y que la igualdad también lo es. Entonces, estas son sus guías para interpretar la Constitución y guiar el papel de la Corte. Entonces, me parece que cuando estamos en el proceso de negociar las disposiciones transitorias, hay que asegurarnos de resaltar los valores de esas transiciones. Esa es una parte bien importante de todos los proyectos y eso facilita el rol de las Cortes.
Muchas gracias, Kate. Voy a hacer dos preguntas que están relacionadas por el tema y es si nos podría explicar la diferencia entre el principio de razonabilidad y el uso del principio de proporcionalidad en la interpretación de derechos económicos, sociales y culturales.
Right. So,
sí.
Under the South African Constitution,
en la Constitución de Sudáfrica, la mayor parte de los derechos políticos, sociales y económicos se formulan en dos partes. Por ejemplo, si vemos la sección 26 de la Constitución, ahí dice que todo mundo tiene derecho a una vivienda, acceso a vivienda. La segunda sección de esa disposición nos dice que el Estado debe tomar medidas legislativas y otras medidas para asegurar que se garantiza ese derecho, que debe proporcionar recursos razonables y de acuerdo al principio de la progresividad. El enfoque de la Corte en este sentido se queda como a la mitad porque reconoce que la segunda parte, el deber del Estado de tomar acciones razonables para garantizar esos derechos, es una definición clara de la obligación positiva del Estado en relación a ese derecho. En relación a la vivienda, lo que significa es que el Estado tiene el deber de tomar medidas legislativas y de otro tipo para garantizar el derecho al acceso a la vivienda. Y usted puede ver que en esa oración está la palabra razonable. La Corte tiene que decidir lo que significa la palabra razonable en ese caso. La Corte ha dicho que primero, no es razonable que el gobierno no haga nada, para nada. Segundo, no sería razonable que el gobierno ignore las necesidades de los más vulnerables en nuestra sociedad y que solo le dé viviendas a los que son más vulnerables. Y después la Corte reconoce que dadas las circunstancias económicas y sociales, no es posible que el gobierno inmediatamente a todo mundo le otorgue una vivienda. Los pasos que el gobierno toma se evalúan en el sentido de si son objetivos, si son razonables para poder conseguir el derecho de una manera progresiva. Esto es diferente al texto de la proporcionalidad, porque en la Constitución sudafricana nosotros usamos proporcionalidad cuando algo que el gobierno ha hecho está limitando los derechos. En otras palabras, si, digamos otra vez, con el derecho a la vivienda, si está un derecho o una obligación negativa porque no se están garantizando los derechos a la vivienda, si el gobierno solamente tomara una parte de la legislación que dijera la gente podría ser desalojada de sus casas porque los dueños, los propietarios eran otras personas en 30 días, esa tierra en manos de quién quedaría. La pregunta es, ¿quién limita los derechos? ¿Eso limita tus derechos a acceso a una vivienda? La pregunta también es si esto es proporcional y entonces hay que ver cuál es la razón por la que las legislaciones gubernamentales permiten un desalojo inmediato para desocupar la tierra de alguien más. Entonces aquí está en juego la legislación que protege los derechos de la tierra. La pregunta es, ¿esto es proporcional también entonces con el derecho a la vivienda? La proporcionalidad sale siempre en donde hay una limitación de un derecho, ¿no es cierto? La pregunta es si esa limitación es proporcional a la limitación dado el propósito por el que se redactó.
Muchísimas gracias. También voy a unir en dos preguntas que creo que están relacionadas en su tema. Por una parte, nos preguntan si podría hablarnos sobre qué tipo de reparaciones puede dictar una Corte Constitucional al existir una violación de derechos humanos y en ese sentido también qué papel tiene el derecho a la verdad, a la memoria y a la reparación en una constitución que tiene que es producto de un proceso de transición y conciliación.
Okay, so I'd like to divide my answer into two. The first...
Quiero dividir mi respuesta en dos. Primero, la pregunta de la reparación, la verdad y la reconciliación y los procesos que vivimos en Sudáfrica. Ese proceso se estableció bajo el marco de trabajo de la Constitución, pero en una parte separada, en otra legislación. ahí se reconoce que uno de los elementos de este derecho a la reconciliación debe ser la compensación. Así que los primeros dos aspectos que tengo que resaltar es que debe de haber un procesos para que la gente pueda, como fue en Sudáfrica, expresar sus experiencias, como en el apartheid, que haya audiencias para que la gente cuente sus experiencias. Esas personas debieron haber recibido compensaciones, reparaciones, pero nunca lo recibieron. En el proceso de reconciliación estamos hablando del derecho a las personas que han perpetrado violaciones a los derechos humanos. Hablamos de amnistía, pero no se puede hacer una determinación a menos de que haya audiencias para que la gente explique sus experiencias y se determinen amnistías, ¿verdad? Hubo muchas personas que no pidieron amnistía y sí habían estado involucrados en actos indebidos en el apartheid. Esas personas, de hecho, no se llevaron a tribunales, pero no pidieron amnistía y no la obtuvieron. Entonces, es un tema de que el proceso de reconciliación no tiene que compartimentalizarse. La gente, por ejemplo, en Sudáfrica no fue llevada a tribunales, aunque no haya pedido amnistía. Bien, ahora hablemos de las violaciones a los derechos humanos fuera del proceso de reconciliación. Y hay un espacio para que haya una reparación del daño. En Sudáfrica, las cortes usualmente sugieren que se busque una reparación del daño bajo las leyes de la responsabilidad civil y que sean en línea con la Constitución. Y básicamente hemos visto casos civiles y violaciones de derechos humanos. Espero que esta respuesta les haya sido de utilidad.
Muchas gracias. Aquí tenemos otra pregunta que es, bueno, en los últimos años en México se han hecho muchos esfuerzos para lograr la paridad de género en el Poder Judicial Federal y usted explicó la situación que enfrentaron en Sudáfrica. Si, la pregunta es si puede ahondar en los beneficios que tiene esta paridad en el Poder Judicial y en las Cortes Constitucionales.
As I say, I think that there are two real benefits.
Creo que hay dos beneficios reales que provienen de esta paridad, ya sea en términos de una paridad de género, de idioma, etcétera. Bueno, lo que pasa es que el pueblo piensa que en las cortes hay gente que se parece a mí, dicen ellos. Entonces la gente tiene más confianza en las cortes. Si la corte no tiene a gente que se parece a ti o que viene de tu entorno, tienes menos confianza en esa corte, ¿no es cierto? O sea, tiene que ver con la legitimidad de la corte. Ese es uno de los beneficios. En segundo, esa paridad mejora la toma de decisiones, la calidad de esa toma de decisiones, no por el perfil de las personas, no porque incluso una mujer represente mejor la agenda femenina, sino que se trata de que haya alguien que tenga un perfil como de las personas del pueblo en cuanto al género, al idioma. Las personas con experiencias diferentes tendrán un patrón menos institucional, tendrán menos sesgos, porque estarán ahí mezclados, digamos, diferentes perfiles, gente que estudió en diferentes universidades. Habrá más formas de pensar, entonces habrá diferentes formas de pensar y por contrario, eso disminuye las capacidades y la eficiencia de las cortes.
Muchas gracias. Por último, bueno, tenemos dos preguntas más. La primera es, bueno, ¿qué factores considera que influyeron en el hecho de que el número de casos de legislación inconstitucional no ha cambiado significativamente a lo largo de la historia de la Corte Constitucional.
So it has been interesting that challenges to
Es interesante que hay desafíos a la legislación. Bueno, no han cambiado los números dramáticamente en el tiempo y nosotros pensábamos que sí iba a cambiar porque a mitad de la era de los 90 había mucha legislación nueva que salió por el tema del apartheid. Creo que hay dos razones. La primera, el Parlamento entre 1994 y 1999 era muy activo en buscar cambios legislativos, en desarrollar en relación a la discriminación. Así que ellos no esperaron a la Corte. Se quería resolver el problema rápido. En segundo lugar, creo que muchas veces no se enfatiza que hay muchos desafíos a la legislación y son pequeños. Hay como apelaciones, pero no a toda la ley, sino a pequeñas secciones que son problemáticos de implementar y no importa que también se redacte una legislación, es bien difícil evitar ese tipo de problemas. Así que siguen saliendo, incluso con una legislatura que no quiera ser injusta. Es muy fácil soslayar estos problemas. Una gran proporción de casos que se reciben tienen que ver solo con pequeñitas disposiciones, pequeños pedacitos de la ley que no se anticiparon cuando se redactó originalmente la legislación.
Muchas gracias. Llegaron varias preguntas más, así que vamos a abusar de su tiempo un poco más. También nos preguntan cómo ha entendido la Corte Constitucional separación de poderes, de división de poderes en sus sentencias.
So this question of the separation.
Esta pregunta de la separación de poderes es el motivo ligero, el tema que aparece en toda la jurisprudencia, hablando en cuestiones de permanencia, jurisprudencia en diferentes recursos, jurisprudencia en la interpretación de los derechos per se. Entonces creo que en Sudáfrica vemos el desarrollo de un entendimiento más dinámico de la separación de poderes que a menudo es entendido particularmente en países del globo norte. Hay una distinción, la separación entre la legislatura, el ejecutivo, el poder judicial y el hecho de que no debe haber interferencia entre ellos, pero no se aplica tan rígidamente. Y particularmente la Corte Constitucional toma el punto de vista de que se necesita garantizar que el marco de trabajo constitucional sea mantenido, incluso aunque eso signifique o aplique al presidente o al ejecutivo, porque a veces el Parlamento a lo mejor no está haciendo lo que tiene que hacer, no cumple con sus deberes. Y pienso que la Corte que hay ciertos sesgos en este sentido, pero creo que en un área de derecho comparado, lo cual veremos que se desarrollará más en los siguientes 10 o 20 años, habrá un repensamiento de la separación de poderes a la luz de la experiencia no solo de Sudáfrica, sino de América Latina y Centroamérica también.
Muchas gracias. También llegó la siguiente pregunta. La igualdad como derecho y valor de la Constitución, ¿cómo protege la Constitución sudafricana a colectivos como la comunidad LGBT?
The equality provision of the South African Constitution
La
is found
disposición de la igualdad se encuentra en la sección 9 y tiene una lista no limitativa en estos términos de discriminación o no discriminación, pero incluye la orientación sexual. Es quizá una de las constituciones más tempranas que expresamente dice que no hay que discriminar con base en la orientación sexual. Y ha sido una enorme jurisprudencia para la Corte desde sus años tempranos, que atiende temas de casos en donde se argumentaba que había habido discriminación con base en la orientación sexual. Hay menos ya porque la legislación casi ya ha sido corregida para asegurarse de que no hay discriminación en este sentido, pero en el pasado la Corte no permitía el matrimonio entre personas del mismo sexo. También se prohibía que las parejas homosexuales o gay de adoptar, también se les prohibía heredar el uno del otro, beneficiarse de las pensiones y, por supuesto, de casarse. Todos estos fueron casos que se presentaron en la Corte y la jurisprudencia más o menos en el 1997 trabajó en eso hasta como el 2006. Pero a partir de ese periodo, los casos han disminuido. Los principales fueron en ese periodo.
Muy bien. Nos preguntan también cuáles serían, a su criterio, las sentencias más emblemáticas sobre derechos económicos, sociales y culturales de la Corte Constitucional Sudafricana.
Quizá una decisión muy reciente de la Corte en el derecho al voto. Es que el sistema de representación proporcional y el sistema de listas de votación que tenía que ser adaptado para permitir que las personas o ciertas otras personas pudieran ser candidatas. Y este es un fallo muy importante y también se estableció pues como uno de los más emblemáticos recientemente, pero hay muchísimos otros casos. Hubo uno de hace 4 años de financiamiento a campañas, las obligaciones en relación a divulgar los gastos de campaña. Ha habido bastantes casos en la esfera política.
Muchas gracias. Y la última, ahora sí, es, en su opinión, ¿qué motivó la incorporación del derecho internacional de los derechos humanos para interpretar el catálogo de derechos en la Constitución sudafricana?
Sí, bueno, creo que hubo abogados internacionales que estuvieron involucrados en la redacción, pero hay una razón más fundamental y esa es que, por supuesto, las resistencias internacionales al apartheid fueron una parte bien importante de la historia sudafricana. En todo el mundo la gente ordinaria expresaba su desacuerdo contra el apartheid. Se comentaba que era un delito internacional, así que creo que al reconocer el derecho internacional como una herramienta interpretativa muy importante en la Constitución sudafricana, es una señal de que había que atender otras preocupaciones también internacionales, derechos humanos, por ejemplo, a la luz del apartheid.
Bueno, muchísimas gracias, jueza O'Regan. Ha sido un gran gusto poder escuchar estas reflexiones, que haya compartido con nosotros sus experiencias, y les agradecemos también a todos y todas los asistentes haber participado, haber contribuido con sus preguntas que indudablemente contribuyeron a la discusión y abrieron formas interesantes de pensar desafíos que tenemos aquí en México con los niveles de inequidad, violencia y desigualdad en múltiples dimensiones que estamos viviendo, y invitamos al público a la próxima conferencia del ciclo, que tendrá lugar el 10 de junio a las 17:30, con la participación del magistrado de la Sala Constitucional de la Corte Suprema de Justicia de Costa Rica, Paul Rueda Rojas. Muchísimas gracias por habernos acompañado.
Thank you very much, Karina. I'm very
Muchas
honored to have
gracias.
been invited. It's been a pleasure to be here.
Ha sido un placer, estoy muy honrada de haber participado aquí. Gracias, estoy muy orgullosa. Gracias a usted, a su equipo, a Roberto Niembro, ¿verdad? Les deseo a todos ustedes y a los participantes el mejor de los éxitos en relación a su justicia constitucional. Muchísimas gracias. Hasta luego.